Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law. Hello and welcome to our 7th podcast in our series. We're doing awfully well. Today we're discussing somewhat of a different kind of case. It's the case of Annette Pendragon and Judy Coom. It was an appeal that was decided by His Honour Judge Kesar. The case addresses one of the big questions of our modern day living, Séverine and Maggie, the status of pets in contract law. And I believe all of us here have pets.
Yes.
A cat, 2 mice and a hamster.
You need to keep them well apart then, don't you, thinking about it?
The cat is actually currently sleeping in my son's bedroom.
Oh, I thought you were going to say the cat is sleeping with the hamster.
No, I think that would be a little bit too dangerous, but, sleeping...
That is what I meant.
Sleeping in the same room as the mice and completely unaware of them. So that's great.
Good mice, then.
And Tim's got a puppy.
Yes. Yes, they're puppies until they're 2 years, and this one's now 1.5. Still behaves like it's about 3 months old.
Now, well, I can top both of you because we've
Go
got
on.
2 donkeys, 4 rescue dogs, 2 cats. The geese were had by the fox, unfortunately. We have a badger that comes calling, but you can't call a wild animal a pet. And I think there's some law on that, actually.
And we're not going to get into that today. No. So, in our case today, Miss Coom decided to buy herself a puppy. Not as a show dog, we have to say, but just as a pet, and that is quite important. Miss Pendragon is the business owner of a business that breeds Old English sheepdogs. And this particular puppy, which was later called Lady, a name which is likely to give the dog some sort of identity crisis, I think, was sold to Miss Coom in June 2018 for a price of £1,000. Believe it or not, the price was lower than what might normally be expected of a dog like this, because Lady was the result of accidental mating, and Lady was therefore never registered at the Kennel Club. That was a sentence I never thought I was going to say on this podcast, now that I'm saying it out loud. We now need, of course, some background on dog health, I think. So I would summarise it as follows. Apparently, dogs can undergo tests for their hips to ensure that hereditary hip conditions are not passed down the line. And in this case, Lady's mother had been tested for hip score, but Miss Pendragon mentioned to Mrs. Coom, I think, that the results were still outstanding. Evidence seems to suggest, though, that Miss Pendragon knew about the results at this point, and that's something that we are going to have a look at, I think, in our discussion. Unfortunately, Lady had to undergo a complete hip replacement by the middle of 2019, and it was then later revealed that further surgery was actually required on the hip, which was then carried out in November of that same year. It was also found that Lady had a form of diabetes, which I don't think we'll go into in too much detail here. It should be noted that before the surgeries took place, Miss Coom had complained to Miss Pendragon of the matter, and Miss Pendragon had proposed that Miss Coom give the dog back for a refund. Interesting. In the first round, then, it was held that Miss Pendragon had the right to refuse the offer of handing the dogs back, that she had a right to repair under the Consumer Rights Act because the puppy was not of satisfactory quality, and she was entitled under Section 24(2) of the Consumer Rights Act to a reduction in the price up to a full refund. Today I have now the difficult task of directing the discussion, since there are so many issues that Judge Kazar runs through. So first was the ground of misrepresentation, which it seems to me the judge dismisses on the ground that it was not actually argued. I'm sure we'll discuss this in more detail. In fact, my first question is probably going in that direction. Second, then, the judge holds that the duty to provide goods of satisfactory quality under Section 9 of the Consumer Rights Act is strict. Third, that the right to repair is not a right granted to the buyer, but is a right to ask the trader to repair or replace the item. And fourth, that the damages were incorrectly calculated. Of interest here is that Miss Coom only asked for the 20% of the veterinary bills, which were not insured by her. The judge therefore concluded that the final sum was for a price reduction up to the full purchase price, plus damages of only £83.49, which was the uninsured part of the claim. I may need to add here that this is a case that was brought in a small claims court, so along that track. There's a lot for us to get through here, so let me stop rambling on and throw out a few questions. My first one, can we really assess whether an animal is of satisfactory quality? There's a lot there. Séverine, what are your thoughts on that?
Well, I think what this case shows is, and I'm going to reply with a little bit of a question. It depends what the animal is for. So here, as a pet, I think the judge himself, did comment on it. It would be a lot easier if this was done for breeding purposes. So here, Mrs. Coom, she clearly didn't want Lady for breeding purposes. She just wanted it as a pet, and in a way that kind of probably complicates the issue, because she, in spite of the problems, and again this is something that the judge commented upon at the end, that she was quite happy to keep the dog, even though the dog was clearly costing her something. And I think the judge made the point of, can you say that something doesn't have any value, when it's costing, what's the value of the pet when the pet has no value and yet it's costing a lot of money. So I would say this would be a lot easier if here it had been a straight case of Mrs. Coom acting in the course of a business, because then it is a clearer business case. But I would say as a pet, it brings actually interesting question to, can you be so black and white? Here we're talking about goods. And so as a pet, can a pet, and therefore in relation to the damages, I think maybe, would we not get into non-pecuniary damages, because a pet is here to bring enjoyment. So does that limit? So all these things, I think this is a really interesting question. And that is how I'm going to answer to it. An animal for breeding purposes, clearly bought for the purpose of making a profit, probably would be a slightly easier black and white. So assessment of damages, the loss of value, consequential losses, etc., etc. But here, what's the loss? Clearly, a dog is a chattel. When I was reading the case, I was thinking, okay, this brings interesting questions to assessment of damages, which of course were not relevant here, so we're not asked, but it made me think a little bit about it. But yeah, so a pet can be assessed for satisfactory quality, because that's what the law requires here.
I think I would say that there is a problem with the definitions, in a sense. I think that's what Tim is alluding to. There's a problem with the definitions applying to a sentient being like an animal. The Consumer Rights Act, understandably, takes its definitions from the directive, because we have acquired, remember, the Consumer Rights Act from the EU directive on consumer sales. And the definition there is movable items. Now, that's a very peculiar way of talking about an animal, in my view, a movable item. you wouldn't naturally call an animal an item. It's probably a bit clearer under our existing or our previous law, the Sale of Goods Act, which actually dates back, doesn't it, to 1893. And an English lawyer would not talk about items, they talk about chattels. So personal chattels, and I think there is case law that decides an animal is a chattel, because to an English lawyer, that's just personal property. So that's about an ownership point. And if you're the owner of the horse or the dog or whatever, that's sufficient for Sale of Goods Act. It becomes a little bit strange when we use the EU terminology of movable items, I think. And that's probably the main beef that I have about using, I'm going to sound contentious now, using the Consumer Rights Act in a setting like this. I can understand exactly how it's come about because, as Tim said in the introduction, this is small claims track, which means you probably don't have a solicitor. Or if you do, you're paying for that solicitor yourself, because you're not going to recover those costs come what may, unless the other side have behaved outrageously. It's very difficult to recover legal costs of that nature in the small claims track, and that goes right up to £10,000. So what's small to you and I, or to lots of people, actually is a different thing, perhaps, from the rules. So it tends to mean, I think, that people making claims in the small claims track are geared to what information they get off the internet and things like that. And so if you did a Google search about consumer, anything consumer, bingo, I think you're going to get the Consumer Rights Act. So Miss Coombs is naturally led, I think, to formulate her claim using the Consumer Rights Act, and therefore using the terminology and the sections and all the rest of it. But I think we tend to forget, perhaps lawyers are as guilty as this as anybody else. We tend to forget that I would say that the Consumer Rights Act, like the Sale of Goods Act, is sort of grafted on top of the common law. And so there's a lot of law, if you like, under the waterline, which would be applicable and perhaps more naturally applicable to a contract of this nature, buying a pet. In other words, what I'm saying is, given that the right of repair was not applicable, given the context, and a lot of the provisions that the judge talked about were simply not applicable, given the particular facts, was the Consumer Rights Act actually much help to the claimant anyway? She could have formulated it simply using the good old common law. What's wrong with the common law? It works quite nicely here, and you don't get into all this tangle about right to repair. Does it apply? And can it apply when you're talking about surgery on an animal? It's a bit strange. So that's the beef that I have with it. I can see how it's come about. Naturally, it's explained by the small claims track background, as I say. But actually, the common law probably would have got to the same outcome here without the Consumer Rights Act.
Would it, though? Wouldn't we say that mitigation would get in the way of that and say, put the dog down?
No, it wouldn't. I mean, that's another problem that I have with this case. I think, with due respect to both levels of judges here, and naturally they have to deal with the case as it's pleaded to a litigator. That's the sort of language that I think we would use. It's pleaded. In other words, it's put on the basis of the Consumer Rights Act. So, as a judge, I think although it's small claims track, you have a pretty much more leeway there, given that it's litigants in person. But nevertheless, you are kind of like caught by the way the claimant fashions their own case. And I think the mitigation arguments got it wrong in the case, and even got it wrong on appeal, I'm afraid. That's my opinion.
I guess here, so, in the light of what you've just said, Maggie, that, because it is where it is and it started, both parties were litigant in person. I think one of them had access to a skeleton argument.
Yeah, I think at the latter stages, Miss Coombs had a solicitor.
Yeah, I think if, what Tim mentioned earlier, if you Google, or Maggie, it's you actually, Google consumer, you will come up, the language of the consumer right, repair and replacement is a lot more easily understood by a lay person, and you may have access.
I think what I'm saying is that the case became hijacked by that statutory provision.
But also, if you look at I think the you made a valid point about the European origin being a bit weird, but if we look at how, I guess, being a civil lawyer, I don't really have a problem with the difference between movable and immovable item, but that's beside the point. But also, if you look at the judgment, the judge reverted quite quickly back to the English parlance of chattel. So, but here I think we can discuss whether, if it had been pleaded on a pure common law contractual viewpoint, whether it would have made any difference.
No, that's what I'm saying. I don't think it would have made any difference. It's just that you don't have this tangle with right to repair. Does that apply or not? Because you're not engaging with the rights set out in the Consumer Rights Act. And remember that the Act itself says that these rights do not displace
absolutely not
the common law.
No.
But you wouldn't expect a litigant in person to actually appreciate the sort of nuances of this quite tangled bit of legislation, and it's there to help consumers, and in many instances it does. But it's naturally tailored, isn't it, for buying a washing machine or a car. And these are the bog standard typical problems that you would get in the small claims tract. Fine, but it's not, that's the only point I'm trying to make. It's not naturally applicable and transferable to the purchase of a dog. It can be made to work for sure, but it's a bit of a struggle, isn't it? I'm not making the point about movable, immovable. It's this word item is a bit strange. Did you talk about your hamster or your cat as an item?
Well, no, you don't. And I think that's what I was trying to say at the beginning, that, it's it would have been a lot easier in a way if it had been a pure commercial transaction, that the dog was an investment. And I think, therefore, that would have been a lot easier in a way. And that's why I brought everything I brought up, with, it's a pet, and, clearly would any, in a commercial setting, I think the person would have put the poor animal down.
Well, yes, that's the other point, isn't it, about applying this, and the judge actually did this quite rigidly. I think I have a problem with this sort of rigid application of the damages are therefore the difference in value of the item. As it is and as it should have been. And because that difference in value was so great, and the cost of repair, again, artificial word in this setting, it means the surgery, was disproportionate, in cold financial terms, that is so. And so, as you're saying, Séverine, that's entirely a natural way of looking at items that are not organic, if you like, that are items in the traditional way we would refer to a thing as an item, a non-living being, I suppose, and it becomes much harder when you talk about living beings as items. But that's the problem I also have with the mitigation argument, because if you look at the case, anyone listening, you will see that the judge simply looks at the sort of commercial value of the puppy, whereas, as Séverine is saying, it was a pet, a puppy. And had Miss Coom accepted Mrs. Pendragon's proposal to take the dog back, what would have happened to the puppy? As you are suggesting, Séverine, the likelihood is the puppy would have been put down. Now, okay, looking at it in sentimental terms, that looks to be unacceptable and unreasonable. But I would say, looking at it as a lawyer, I think on these particular facts, I think that means Miss Coom's response was entirely reasonable. And remember, that's the word that we should use for mitigation. Was her behaviour reasonable in the circumstances of that particular case? And because the lady had pet insurance, I think that makes it even more so. And now we're moving into a commercial position, if you like. She had paid for the pet insurance. She had the benefit of it. I would say it would be wholly unreasonable for her to have said, well, forget my pet insurance. Yes, you have the wretched dog back, and if you put it down, then you put it down. Because she had the pet insurance. It would be entirely reasonable to claim on that insurance, and indeed the pet insurer didn't appear to have any difficulty in paying up. And so they bore the brunt of the £10,000 total bill, I think it came to. Less the 20% that Miss Coombs had to foot for herself. But she has paid for the benefit of that separate contract, remember. So I think that's a point where I think the case really came off the rails, actually, on the mitigation point. Don't know what you think about that.
Would it help if we saw the dog more as a unique item?
Yes,
because so far we're thinking of the item as in you pay £1,000 and you get the same dog. Well, that's simply not true. No. We're getting something that's quite unique in character, in being. I'm thinking of old Chinese vases, things like that, along that category. Is that going to help us in any kind of way? Let's say we are going to frame this outside of the Consumer Rights Act. Would that help?
I think it would be difficult to argue uniqueness, because, if you look that up in a dictionary, I think you'd have to say there is nothing equivalent to that. I know Old English Sheepdog breeding is actually in decline now. And I think I saw something in the Times a couple of weeks ago, you might have seen it, that the breed is possibly going out of existence in this country because people, they're expensive and they take a lot of time and care, grooming and so forth. Listener, if you don't know what an Old English Sheepdog is, Google the Dulux paint advert and you will see an example of an Old English Sheepdog. They have a lot of hair and they are a very large dog. So they would be expensive and time consuming to look after properly. And it's because of that, I think, that the breed is in decline. But even so, Tim, I don't think you get far in a court arguing that a puppy is unique. It would be different, maybe, if your puppy was a winner at Crufts, for example.
But can you, again, the question of a unique chattel was, very briefly looked at. But if we think of it in terms of, so the way this dog came to be as an accidental mating, Well,
I think this is because, isn't it, that the mother that Tim referred to had a high risk of carrying hip dysplasia. She wasn't herself showing any difficulties. She didn't have hip problem, but genetically the test would have come back as a high risk, and it's because of that, I think, that the Kennel Club would have said and put on her registration that this animal is not to be bred from. So to that extent, it's an accidental mating, because the breeder obviously knew that she couldn't really register any of the puppies that might come from that.
I know. So therefore, the breeder would not, because of that, breed her. So therefore, that's why in that way, she is unlikely, having been bitten once with this case, the breeder is no doubt going to be very careful as to where this, dog or, the mother is going to be in contact with other males. But therefore, as a result, you could say that it is a to put it in blunt commercial term, that is not in the financial interest of the breeder to have that bitch breed anymore, because clearly, she has lost a lot of money through that. So therefore, in that way, could we consider that it is a unique item? I know we usually consider unique item as irrepressible because they are so unique and, they are one of a kind, because they are so expensive. Here, she is lady is also a unique item.
I think the law. Don't you agree that with this, the law would have difficulty accepting that a dog without some special characteristic is.
Well, wouldn't the DNA itself be unique? Right? My dog has this DNA, and up until the point that we can create them in a petri dish, it remains unique. You can't get that combination again.
Ooh. Wow.
Thank you, Séverine.
Well, the law uses this concept of uniqueness. The law uses the concept of uniqueness surely as an explanation for a difference in value.
Yeah.
And it's about the monetary market value of the thing. An Old English sheepdog that is unexceptional in breeding terms will have a market value if you're looking at it purely commercially, but I think it would be very difficult to successfully argue with a court, at any rate, that makes it unique. If it was, like Red Rum, for example, the racehorse, or Desert Orchid, the racehorse who's won so many races, or a breeding mare, for example, or a male. That would be a different kettle of fish, I think. That would be getting closer to your analogy about as an antique. But an ordinary, if I use that word, dog of a particular breed, I think you would have real difficulties claiming uniqueness.
Yeah, she's unique for all the wrong reasons. Uniqueness, you're right, is usually pleaded in order to claim, really high damages. Here, she's unique for the wrong reason, because she is so, apart, and that's where I go back to the emotional value associated with a dog, that the owner did take insurance, which is not cheap, and therefore is perfectly happy. She's not going to claim for any more of the pet, because I think aside what you said, Tim, I think she's also going to be in need of the second hip to be replaced. So it's not as if
interesting point on the surgery.
Yeah.
I think if you look at the judgment, the first surgery failed. There was some problem with it, and she had to have further surgery. Now, I can entirely see that the second lot of surgery would not be reasonably within the contemplation of the parties. So your Hadley and Baxendale probably knocks that one on the head.
No. I wasn't referring to that. I was trying to refer to the fact that I thought I had understood that. So she's had one hip replaced, but I understood that it was likely that she had the second. She was going to have the second hip to be no. Okay, well.
No, she had the second. She had it done twice. Same hip twice, I think.
I know, but
and the other one I think is fine.
Oh, okay. I understood. I know she's had one that failed, so therefore she's had a second surgery. But I had understood that her other hip was also going to be in need of replacement.
Which brings me on to the next point is of this whole satisfactory quality. Now, where do we draw the line? So, say you get a dog which is, I don't know, allergic to grass. I mean, that is probably going to fall outside of this, and you all know that I'm doing this just to fan the fire a little bit. But, it seems to me here that this all comes down to a manufacturing defect, if I may call it that.
A latent defect.
Well, here we're talking about a genetic defect, aren't we?
Yes. That's what we're talking about.
So, presumably, if we could then prove that the hay fever or whatever comes down the hereditary line, we would be able to claim that back for our dog.
Well, no, you're back down the difficulties, I think, of applying rigidly the terminology and the provisions used in the Consumer Rights Act into an animal situation. It's entirely applicable to do these sorts of questions where what you're talking about is a car or a washing machine. The Consumer Rights Act talks about freedom from defects, doesn't it? And more will be expected of a brand new thing than a second-hand thing. But you can see how this does not really fit with a sentient being, a living animal. Very few of us, probably nobody on Earth, is free from all defects, regardless of one's age. Tim's putting his hand up now, claiming perfection. Only God.
I didn't know I'd be given away there.
But that I just sort of offer that to show how ridiculous it is, really, to try and talk about freedom from defects when you're talking about a living item. Living items are never free from something, hidden or otherwise, latent or patent. So the Consumer Rights Act is an unnatural thing, I think. In many instances, it will apply entirely satisfactorily to living things. But when you get to these very fine points about defects and what that actually means, perfection, it can't possibly mean perfection in a living animal.
I mean, I think to be pedantic, it's freedom from minor defect, which refers to something quite technical. But
that would be a new item, wouldn't it, Séverine? You would not expect a second-hand item, for example, or something that's been living, if I use that sort of way of talking about things, for a period of time, to be free from maybe major defects. Do you see what I mean?
No, it's just because of the expression that we were using, freedom from defect. It's something by the fact that something is not of satisfactory quality, it will be defective. I was just being pedantic about the expression freedom from minor defect, which makes reference to blemishes and things like that. And I think that's clearly not what we are talking about
here. But my point is, what the standard is of a new item, a brand new manufactured item, is entirely different from something that is second-hand, and the legislation all accepts that.
Yeah, absolutely. Yeah.
So let's move away from the legislation in a bit. This whole thing about misrepresentation, an implied term, an implied claim for misrepresentation.
Well, you can't have an implied. No, you can't have an implied.
That seems to me what Judge Kazar is saying. You can't have an implied term.
Because if you think about it, misrepresentation is quite a serious thing to allege. But you've got to allege it. All right. Any claim that you make, and now I'm wearing my civil litigator's hat and getting heated about this implied assertion. You can't have that. That's not fair. Think about access to justice. If you don't want to buy my civil look at things. If you've got an allegation, you make it clearly, set out what the facts are, and that's the agenda, that's the menu for the court. But you can't have an inference or a suggestion or a half thought of something. You either say it or you shut up.
But don't you think Miss Coom thinks that she said it? I mean, remember that she's not represented here. She's saying, Miss Pendragon, she lied to me. That's got to be the same as saying there's a misrepresentation. And we'll talk about the lying part is a bit extreme.
I hope that wasn't put in that way, because if you suggest someone's lying, that is one of the most serious things that you can allege. That's knowingly saying something.
I do think the judge said it fell short of that. I need to caveat that.
Yes,
he did. I think they said it fell short of fraud.
I thought what the appeal judge was saying is most of what Miss Coombs was possibly suggesting, although not clearly pleading, was really non-disclosure. So that's an interesting point in terms of contract law, because remember, there is this very clear, bright line, which is rather muddy for insurance law, but very clear for general contract law, that the obligation on you is not about disclosure, it's about accuracy on what you say.
Yes.
And how you behave. So we're looking for a positive thing rather than a negative thing. And I think if the judge is saying, well, most of what is being said by Miss Coombs is really non-disclosure. If she really meant misrepresentation, then she would have had to have come up with a lot more factual grounds for that. So the inference, I think, what I get from it is that the breeder, Mrs. Pendragon, had taken the mother of Lady, the puppy, to the vet, and she had an X-ray, and she's trying to knit all that together and say Mrs. Pendragon must have known that there was a high risk of hip dysplasia in my puppy, and she didn't tell me that, and she gave me every inference to believe that there was no problem at all, and so do you see it's that very grey area between non-disclosure and misrepresentation, and not saying something as opposed to saying something. But
it seems to me in the judgment it says Miss Tragan told Miss Coom that had been tested for her hip score and that she was waiting for the results.
Yeah, because that's two different things. Remember, if you look at the case, and then
it later says, okay, Miss
there
Coombs
is an
evidence,
X-ray, and Miss Coombs' own expert evidence. Her own expert says most vets would not have given a judgment on the X-ray, because reading the X-ray is a specialist technical task. And most vets are not actually attuned to do that. That's not really what they're asked to do. So a specialist would have to look at that. So her own expert undermined a suggestion of misrepresentation, because it was likely that the vet didn't commit themselves to Mrs. Pendragon when looking at the X-ray, because they themselves wouldn't have been sure. They were waiting for the technical test to come back, and that's not an X-ray as I understand it, but some other test.
Now it seems to me in this whole thing that it's a bit odd that Miss Coom only claimed for the part of the insurance that she had to pay.
Well, not odd.
Why?
Not odd if you look at it as small claims track without a solicitor. And indeed, she ended up with a solicitor later on, I think. But someone who doesn't really know what they're about, if I can put it rudely, perhaps innocently, entirely correctly would think, I can only claim for the amount of money that I've had to put my hand in my pocket for. Entirely honest way of proceeding, I think, for an ordinary person, Joe Public, as it were. So she thinks to herself, well, I've only had to pay 20% of this bill, therefore I can only claim 20% of the bill. Yeah, entirely reasonable approach for anyone to take. It's just that the law would say you could claim for the full amount, but here's the sting, you can't keep the full amount.
Yes.
You would have to pay back to your insurer the 80% that they've paid. So I don't know, maybe somebody said that to her, so she didn't want to involve the insurers, so she just said, oh, well, I'll just claim for the amount that I've actually cost me. So that could easily be the explanation.
So how would we frame this case if we were going to bring it? In other words, what did they do wrong?
I wouldn't be banging on about the Consumer Rights Act. I would be banging on about the common law express or implied term that the puppy, although an unintended mating, there was no reason why she would have any hip problem. And nobody knew about the diabetes.
But you see, so the beauty about bringing it under the Consumer Rights Act is that she doesn't have to prove that there is an implied term as to satisfactory quality. Whilst if she does, so that's one aspect, because it is implied into the contract. Would a court imply that it is necessary for the contract that, given that she was told that the pet could not be used for breeding purposes, would her court have found necessary to imply the satisfactory quality? I don't know. That's an interesting question. Just thinking on my feet right now.
It would be down to what passed between the parties at the time when they were negotiating the purchase. The buyer knew it was a cheap, I don't know what a pedigree puppy Old English sheepdog would cost, but she paid £1,000, and apparently that was less than a pedigree puppy. Right. So she knew it was cheaper because the evidence, I think, in the judgment says she knew it was cheaper, but the way in which it was expressed to her was that it was cheaper because the puppy couldn't be registered with the Kennel Club because of the way in which she'd come about, as it were. Not that she had a hip dysplasia risk or problem.
No.
But because hip dysplasia must have been discussed, because you yourself, Séverine, said something about they knew that there was some testing being done and they were waiting for the results. It would be around that. That would be the critical bit of the evidence, I think. What was said by Mrs. Pendragon at that time and what was understood by the way in which she was behaving about that, as far as Mrs. Coombs is concerned, did the puppy have an appreciable risk of hip dysplasia or not? To understand whether the buyer is taking the risk of that. Do you see where I'm going with that?
Yeah, no. I'm trying to think on my feet whether the court would find it necessary to imply, because so in terms of the dog, would you find that when you buy a pet, it is implied that you buy a pet to bring you enjoyment for a certain amount of time? Therefore, if that amount of time is, one of the things that I don't know whether that dog is going to leave, once now that the surgery has been done, I don't know what is the life expectancy of that dog. Clearly, that dog is going to be costing an awful lot more than because she's going to be on drugs for the rest of her life. Would that be when you buy a dog?
That's the diabetes problem, I think, which would not have supported the claim because.
I know, but the fact that the dog has had surgery, that means I'm just trying to think on my feet here. Would it be necessary for the purpose of the contract to imply a term that a dog that you buy has to be of, for want of a better word, satisfactory quality, that you're going to expect a dog to be free of latent defect, which means that
not any latent defect, but a serious one that would necessitate hip replacement? Yes, I would say so, because you buy a dog on the expectation that it will, all being well, live for say 10 years. That would be quite a standard age, and for an Old English sheepdog, I think that's also so. So you would expect that whatever defects it have, if we use that word, would not be something to require surgery within the year of buying the animal.
But anyway, I think what it still means that you would not expect given that we are in the county court, in the
we are. Yeah.
Yes, we are in the county court. That, in the light of what we were saying earlier, I think our answer to the very first question, why, because it would need to be established, it would need to be proven. Surely a litigant in person wouldn't have the knowledge to establish that there is a need to imply a term, whilst under the Consumer Rights Act it's established as a matter of law. So that's why she probably pleaded.
Well, I'm not sure that a litigant in person would appreciate any of that either, actually.
I know.
I think somebody would have just said, refer to the Consumer Rights Act. And section this says that, and section that says, and you will get your money. I mean, that we are attuned now to naturally think consumers, therefore Consumer Rights Act. But that's really my point at the beginning. It's additional to the common law. It does not displace the common law. I accept entirely that if it says something contrary to what law we had prior to 2015, fine, then the Consumer Rights Act is king and must hold the day. But where they are entirely consistent with one another, we must not throw the common law out of the window. But yes, I can see it's unfortunate. Small claims track. Poor old Miss Coombs on her own, knowing no law, and got a sick dog. What is she to do? Yeah.
So what do we think then? On what was pleaded, was it the correct result?
Correct result, wrong damages, because this is my beef about the mitigation. I would have given her 20%, because that's all she had claimed, 20% of the hip dysplasia costs of the one lot of surgery, but not 2 lots of surgery, on the basis that 2 lots of surgery would not have been within the reasonable contemplation of the parties at the time of any sale, really, of an animal. But 1 lot, and I wouldn't have given the damages on the basis of a reduction in price. It would be the surgery costs and formulated on that entire basis. So really, all of this I'm bitching about is probably £1,000, because looking at the very simple figures that we've got, if we for sake of argument, and I think that's more or less the sort of idiot total that the court came to, that the total was about £10,000, but the claimant had restricted herself to 20%. Even on my idiot maths, that's £2,000. She actually got a fraction over £1,000. So I'm bitching, if you like, about £1,000. But I don't like the way it was formulated, that's all.
Séverine?
Yes, I probably would agree with, what you said. Yes, I also, the bit about mitigation, I think what she did was perfectly okay. And so therefore here we go back again to whether, these kind of act is this kind of legislation, and talking about it in, detached goods, chattel, whatever the way we want to look at it.
Here's the problem of small claims track again, because what litigant in person would comprehend that mitigation has to be pleaded by the defendant. The burden is on the defendant. The standard is objective, but not a high one. All of those bits of law, if you like.
Yes.
And then my additional argument that the insurance is a relevant fact, a relevant circumstance in order to judge whether the claimant has been reasonable or not. And that's my main beef about the mitigation. And there's very little, if anything, in the judgment about that. It's simply looked at brutally, if you like, crudely, as if you were buying a washing machine or a car.
Yes.
And you could give them the damn thing back and had your money back. End of problem. And that's why I have this problem about transposing all of this legislation into a situation of buying a puppy.
Yes.
And I think we've learnt an awful lot with that. For one, if you'd like to know more about the whole mitigation business, do check out our podcasts 5 and 6, in which we touch on quite a few of those points. But we've learned, of course, first of all, check the DNA of your pet before you buy it and get legal advice before you go to court. Thank you very much for listening. Thank you, Maggie. Thank you, Séverine. And if you have any ideas, any suggestions, any comments, anything you think we should be discussing, no promises that we will do that, but we'd love to hear from you. Send us either a voicemail or an email to unpacking.contract.law@gmail.com. Thank you, and well, till the next one.
Thank you very much.
Bye-bye.
Bye.